Hi, this is Benjamin Jaffe with SQ Law. I wanted to talk to you about the idea of self-defense in Indiana today. We have increasingly gotten searches related to this, and so when things are timely in terms of topics that people want to know more about, we like to talk about that a little bit more. We do have a blog on self-defense in Indiana, and I would ask you to maybe check that out if you're interested in this topic or you'd like to know more about it, or kind of have it something you can read and look back on. But in general, Indiana has very robust self-defense laws. The law in terms of what you can and can't do is written to provide you with a lot of ability to protect yourself. With that being said, and probably the biggest theme I want to get across here, that decision or a decision to protect yourself with certain amount of force, especially deadly force, is going to be assessed later on by a prosecutor's office, by police investigators, and potentially even by a jury. And so those are the real limitations, not necessarily the way you interpret the law. So first of all, I do want to talk about the law. In Indiana, a person is justified in using reasonable force against an attacker to protect themselves or another person, but you must have a reasonable belief that you're protecting yourself from imminent use of unlawful force. In general, you have to believe, in order to use deadly force, that someone is either going to kill or seriously injure you. And usually people are most interested in the idea of deadly force and when you can use deadly force. And when I say deadly force, I mean taking an action that can hurt someone seriously or kill them. Generally, we will see something like a shooting in self-defense and that being brought up. And so that's probably the thing people are most interested in. I don't think people have too much of a problem with if someone's, getting in your face in an aggressive way, or they raise their fist to you and you putting a hand out on them or pushing them back, whether that qualifies. I don't think people have much trouble wrapping their head around that. The issue becomes, at what point are you able to protect yourself in a way that could really hurt someone? So again, you are allowed to protect yourself. And there's also been, there is this idea of the stand your ground law or something. I never really liked the idea of a stand your ground law or whatever that necessarily means, because I think it's kind of incorporated within the statute when you're able to use deadly force. But there were statutes previously in a lot of states, and maybe there's still some out there in other states, that required you, or you had a duty to try to retreat from the situation prior to actually using deadly force. Indiana does not require you to have a duty to retreat. So you do not have to try to remove yourself from the situation. You can stand your ground without doing that, and you will still be able to avail yourself of the self-defense claim if people believe, or you believe, that you are in danger. And so it's really an assessment. What kind of danger are you in? Is the force that you're using necessary at that point to protect yourself and or another person from serious bodily harm or death in order to use deadly force again? That brings into play this whole idea of proportional force and things less than deadly force, like just hitting someone or pushing them away or brandishing a weapon or something along those lines. Those things would likely fit into areas where you're using less than deadly force. And again, the question there is it proportionate? So if someone says to you, from across the street, hey, you're a jerk, and your response is to point a gun at them, that's probably not going to qualify for self-defense because, number one, it's not really proportionate to the amount of harm they've done. And again, you may not really be in any kind of danger other than it's annoying and or upsetting. There are times when someone's words and or actions can combine to make you feel threatened. So if someone's calling you names or saying really harmful things to you in terms of, to hurt your feelings or something like that, there is this concept of fighting words. And when you combine that sort of thing with someone's actions, for example, if they're coming towards you in an aggressive manner, that can often justify a response. Now, whether it justifies a response that escalates it to a deadly situation, that becomes the real issue that people have to be careful about. But usually, like I said, people are asking about the idea of deadly force. And again, deadly force, you have to believe that you or someone is going to be harmed, seriously harmed, and or killed in order to use deadly force. And deadly force can take many forms. I mean, hitting someone with something, using a knife, using a gun, all those sorts of things would qualify for something that would likely, be deadly force used against someone, especially, if you're using, let's just say you pick up a stick and hit someone in the head. Well, they better be about to kill you or seriously injure you if you decide to make that choice. And again, these choices are made pretty quickly. You don't have a lot of time to think, but I always tell people this is all going to be assessed by someone else later on that is not afraid. At that moment, they're deciding whether you were. They're not in a situation where they feel desperate. They don't feel trapped. They're not in the same place as you. And so you really have to be careful about what you do. And my advice to people is always try to get out of the situation if you can. I think most self-defense coaches and things like that always advise people if you can, diminish it by getting yourself out of that or something, it's going to help you a lot. In addition, it could help you a lot factually later on. If I have a client that uses deadly force, but there is an indication that they tried to, dispel the, the seriousness of the situation or diffuse the situation or remove themselves, and this person prevented them, oftentimes that's going to be a really good fact for us as attorneys if we're arguing. Often that's going to make a difference in the way it's assessed by a prosecutor's office and or investigators as well. And I think jurors always like to think they're going to handle things in the best way. I don't want to say always, but oftentimes they judge you by the way they would have handled it. And I'm always concerned as an attorney, are they going to hold you to this like super high standard of I would have walked away, I wouldn't have done this. And so you just don't want to be in that situation where jurors are assessing your actions and, probably when you were afraid, when you were desperate and you were looking for an out. Or you felt like you had no choice. So again, Indiana has very robust laws on self-defense, but those laws are going to be interpreted by real people that aren't in your same shoes. So you have to be careful about that sort of thing.